Hello everyone. We are here to give you some information about the topic, the interpretation of notice. The concept of notice for the purpose of the transfer of property is given under Section 3 of Transfer of Property Act 1882. Now what is a notice? Notice means to have knowledge of something, that is, to know something. In law, it means knowledge of a fact. It is used to decide on conflicting claims of two parties, and in law, the notice or knowledge of a fact affects the legal rights and liabilities of a person. Under Section 3 of the Transfer of Property Act, a notice can be defined as actual or express notice or constructive notice, or it may be imputed to the transferee when information of the fact has been obtained by his agent.
Now let's start with actual and express notice. Actual notice means when a person actually knows about the existence of a fact. The fact must be definite information given in the course of negotiations by a person interested in the property. The information of the fact should not be a rumor or hearsay and thus is not bound by such information. In other words, actual notice takes place when the information is such that it would operate upon the mind of a rational man and would make him act based on the knowledge so acquired.
Now, what is a constructive notice? According to Section 3, a person is said to have notice of a fact which he would have known, but for his gross negligence or willful abstention from making an inquiry or search, does not know. However, it is such knowledge which a person with ordinary prudence ought to have known. In other words, constructive notice of facts are those facts which a person ought to have known, but because of gross negligence or willful abstention does not know about it. Thus, in constructive notice, there is a legal presumption that a person should have known a fact as if he actually knows it. Therefore, constructive notice is the knowledge of those facts which a court imputes on a person. If the circumstances indicate that a reasonably prudent person ought to have a particular fact related to the transaction of transfer, then he will be deemed to know about it.
Willful abstention can be understood from observations made in Jones versus Smith. Cases in which the court is satisfied from the evidence before it that the party changed has designedly abstained from inquiry for the purpose of avoiding it was stated in this case. For willful abstention, there has to be some starting point, some hint or suspicion which would require some investigation to reveal the truth about a transaction. If in such cases the transferee fails to investigate with a fraudulent intention to not know the real truth, then the court will assume that the transferee had some idea of that fact. For instance, if a property is mortgaged to a bank but deposit the title deeds and the mortgager later sells the property to a lady without disclosing the fact to the mortgage, and she does not insist on inspecting the title deed, then it will be presumed that the buyer willfully abstained from inquiring and will be imputed with constructive notice of the mortgage.
Now moving on to the next concept, which is the gross negligence. Constructive notice also applies where the transferee ought to have known some fact, but because of gross negligence, he is unaware about it. Gross negligence was explained in the case law of Hudson versus Winnie, as gross negligence does not mean mere carelessness. It means carelessness of such an aggravated nature that indicates an attitude of mental indifference to obvious risks. For instance, if the transferee fails to read a note on the paper that the property is subject to a charge, while the papers are in his possessions, then the court will not entertain the plea of no notice and will impute knowledge or notice of charge. Thus, constructive notice demands due diligence with respect to transactions related to the transfer by the transferee.
Now let's understand registration of document as constructive notice. According to explanation 1 to section 3, if a transaction relating to the immovable property needs to be effected by a registered instrument under law, then the registration of the document will be deemed as constructive notice. The notice of such instrument will be deemed from the date of registration of such instrument. It must be noted that registration amounts to notice only when it is required by law. If registration is not compulsory under law, then the fact of registration does not amount to notice under TPA. A sells the house by a registered document to B. He later enters into a contract with C to sell him the same house. Law imposes a duty upon C to inspect the registration at the registrar's office, and if he does that, he would come to know about the sale in favor of B. A's failure to inspect the register will be detrimental to the interests of C, as he would be imputed with constructive notice of the registered transaction. All purchasers are thus under a legal obligation to exercise diligence in examining the title recorded in the register to avoid uncertainties and the risk of any sort. Further, explanation 1 to section 3 states that constructive notice of registration will take place only if 3 conditions are satisfied. The first one being that the document was registered in accordance with the Registration Act of 1963. The second one, that the instrument of memorandum has been duly entered in the book or registers kept under section 51 of the Registration Act of 1908. The third one being that the particulars of the transaction have been correctly entered in the index under section 55 of the Registration Act of 1908.
Actual possession as notice. According to explanation 2 of section 3, a person acquiring any immovable property shall be deemed to have notice of the title of any other person who for time being actually possesses the property. It means that when a person other than the transfer or the owner is in actual possession of the property, then it is necessary for the prospective buyer of that property to ascertain all the rights which the person in actual possession really has related to the property. Thus, it is the duty of the subsequent purchaser to inquire about the purchase character of possession from a person who for the time being actually possesses the property. For instance, A let out his property to B by a registered lease deed for 10 years. Before the expiry of the said period, A enters into the contract with C by which he agrees to sell it to C for a consideration. Now, C must inquire from the tenant B about the nature of the possession by B, because C nevertheless will be bound by the constructive notice of B's title. However, a constructive notice of possession, the possession must be in actual and not constructive possession. For instance, A contracts to sell land to B and B puts another person in possession of that land. A further sell land to C. In this case, C is not affected by the notice of B's interest. Notice of agent. The general principle of the law of agency is that an agent stands in the place of the principal. Thus, notice of fact by the agent will be deemed to be noticed by the principal as well. This is based on the legal maxim which says, he who does by another does by himself. The notice of a fact will be imposed on the principal irrespective of whether his agent did actual communication the fact to the plaintiff or not. Principle behind this is that no person would be allowed to get rid of the doctrine of notice by simple employment. simply employing an agent. This is to protect the innocent party. In case law of Gokul Das versus Eastern Mortgage and Company, it was held that the knowledge or information obtained by a solicitor or in any other case will be bind as will. However, the agent knowledge will not operate as knowledge of the principal, where the agent fraudulently conceal the fact from the principal, but concealment of fact will be not amounting to this aspect as in defense. For this to act as a defense, the party inputting constructive notice to the principal must act in collusion with the agent or is aware of the agent's fraud. So in conclusion, so now the conclusion. Thus, it can be said that the constructive notice is a manifest of the rule of caveat emptor. This is because according to the constructive notice, a person ought to have the information, a fact, as if he actually does know. The property in translation, a transferee ought to ascertain and verify certain facts for safeguarding his own interests. Thus, he must be aware of nature and transaction. These facts may relate to property or the transfer, like whether the property is free of any charge or encumbrances, or whether the transferor is competent to transfer the property or not. If the property is encumbered, then the exact nature of the encumbrance ought to be ascertained by the transferee. Law put it as the duty of the transferee as a reasonable prudence person to be reasonably vigilant and vigilant to ascertain the fact, inspect the document related to the property in possession of the transfer, inspecting concerned person, even with relevant statute authorities, if failure to do this would result in the imposition of constructive notice.